Shaw here again, your friendly local constitutional coop from California. And as you know, there's been a lot in the news recently about Section 3 of the 14th Amendment used as a prohibition against Trump from running for president again. And it's all BS, and I think a lot of the mainstream media even knows this. But just recently, as you may also be aware, the Colorado Supreme Court in the Centennial State, and that's with an SIN, uh, just ruled that they're going to have him taken off the ballot because he engaged in acts of insurrection and rebellion. BS. He did exactly the opposite, especially with his appointees on the U.S. Supreme Court. Now they've been acting like an Article 3 judicial court the first time in 90 years. And going back to the original intent of the racist framers of the Constitution. To be sure, by today's black with white standards, that can be perceived as insurrection and rebellion, but against federal, regional, martial law rule, and against an amendment, as you will learn from getting my modestly priced constitutional defense document packets. Send me an email, uwinandcourt@gmail.com. 14th Amendment not only does not exist along with civil rights, it never has, being contemporaneously ruled unconstitutional by the U.S. Supreme Court in the case of Ex parte McArdle 7 Law 506, which I'm sure all of the current justices know exactly what I'm talking about. It's even worse, really, because when you get into court and the 14th Amendment is all they have. That's the only body politic they recognize, otherwise known as subordinate corporate citizenship. And that was a secret um, plan by the New York banksters with that amendment. No one who ratified it had any clue that's what they were really doing, while at the same time creating quote unquote new states, which Congress doesn't have the power to do, a plain violation of Article 4, Section 3, and also uh, destroying the sovereign body politic of the nation and republic. And whether you like it or not, that's free, white, male, 21, no apologies. Uh, and we haven't been around for 150 years. There's good news in it for all of us across the board. Doesn't matter who you are, because you got nothing with civil rights. And if the cases of Zakiya Young and Jalen Walker haven't brought that home clearly and unambiguously, I'm hard pressed to understand how you're going to want to get any of my work. It goes exactly the opposite direction in favor of the federated Republican form of government of defined and limited powers, and urging the extinction of today's elective despotism, about which those racist framers like Jefferson and Madison were so worried. I believe you can find that in Federalist Papers number 28. And that's what you'll also learn, because that amendment, it did away with the states. And effectively, we can prove for that reason, among others, there hasn't been a lawful election. Ready for this one? November the 6th, 1860. Simple. Where the hell is the consent of the governed here? Ain't nowhere in sight. And that's all they have are these administrative tribunals. And that's what the courts in their fourth term now have an all-out assault on the administrative state. They get it. They haven't gone as fast as I want, nor as clearly as I would like them to at this point. And I know there's no convenient time to get into the issues of first saying, no constitution, no states, no electorate, no jury trial, you name it, no habeas corpus. And by the way, I just recently in my Iowa case had a 52-page unopposed writ dismissed by a judge there, quote unquote, and a Trump appointee who you would think would know better, for the reason it wasn't on the proper fucking form. Give me a break here. 52 pages. But that's because it goes back, and the clerk of court, by the way, changed it. Page 1 of that says non-statutory federal writ. The clerk of court, on who knows what authority, that's full warranto, changed it to 28 USC 2254, otherwise known as the War Act of the 39th Congress, the Habeas Corpus Act of 1867. We can't use it. I've never used it. The clerk has no authority to do it. Although the good news, think about this one. If the clerk can do that and they can't exercise the judicial power of the United States, we're not in a judicial court. If that's true, where do these Article 3 judges appointed as judicial officers have any authority to rule in a legislative or executive tribunal? Can you say separation of powers? Can you say winner, winner, chicken dinner? That's an issue I think the court's ready to rule on this term, and I'm doing the damn best I can to get that one to them. And a lot of other things besides, as you'll learn in other videos. And by the way, on that point, please send me an email, youwinnincourt@gmail.com, to get information about my modestly priced materials and what we can do to help you in a variety of situations, particularly now with the child procurement sending. Just come along and steal your children for any reason, no right to a hearing, certainly not in a judicial court. And even administratively, you're going to get thrown out for going in there and bringing specious, frivolous, sovereign citizen arguments. And the attorneys, even if you have a right to counsel, are not going to go in there and raise these issues for a variety of reasons that you'll learn by getting my materials. Send me an email, youwinnincourt@gmail.com, including the fact that what they really are unregistered foreign agents of the City of London, and all of them have irreconcilable conflicts with our issues that challenge what I call their malignant, malevolent monopoly on the practice of law. Enough already. And all of this from a simple matter of the Section 3 of the 14th Amendment. We have a great opportunity to get rid of it. The justices aren't going to rule that on the Colorado case, to be sure. They'll find some other way at the moment to get around it. But we have a clear majority, if not all of them, that know exactly what I'm saying. The amendment doesn't exist. You want to get back to that original Constitution? No, it wasn't a perfect government. There never has been one. Only the best one ever invented. We want it back. You can make changes from there and do it, correctly and in accordance with the Constitution, and get some better results across the board. So that said, it's exciting. For me personally, I just turned 75 recently. Life is still ahead of me. And especially with this court acting the way they're acting right now. Never thought I would see that, but we're in our fourth term. And if Trump wins the quote-unquote election, which seems likely, now Alito and Thomas can retire. We get two younger ones on there, and we're good for the next 12 to 15 years. That's when the big push is really going to come, because there's nothing the Democrats can do about it. They tried it once with good old Franklin Delano Roosevelt, and he had a strong majority in both houses and couldn't get a bill passed, to create new, to pack the court, because he wanted to go from 9 to 15, because all these justices, well, not all, it was 5-4 ruling against him in his FDR and his New Deal BS. And he finally got the switch in time that saved 9 by owing Josephus Roberts. You'll learn more about that too by getting my materials. Send me an email, youwinnincourt@gmail.com. But even with strong majorities in both houses by the Democrats, he couldn't, manage to get that done, and they're not going to get it done now. And even better, and it's the same situation, by the way, in 1937, because we haven't had any qualified members in Congress, either house, for 140 years. We'll learn all about that. Send me an email, youwinnincourt@gmail.com. I don't give a rat's ass what they think the laws are on the books. They ain't there. And none of them apply to lawful digital, just sanguineous state citizens either. Not to mention the inhabitants of states and even the inhabitants of territories. And they are assured of the right to trial by jury according to the course of the common law and habeas corpus. And yet both of them have disappeared like a fart in the wind. And you'll learn a lot more about all that. Why? Send me an email, youwinnincourt@gmail.com. And we could have some other issues to discuss, like working together too. I'll be coming up with a video about that subject. But this one has laid things wide open. And we get there with the right questions and the right forum will be in the original jurisdiction of the Supreme Court, by the way, not the appellate side. And they know very well why. So we get there and get our issues decided. And that's great news in a lot of areas. For example, we get one ruling against a quote unquote landlord with an eviction that undoes evictions all the way from Portland, Maine to Portland, Oregon. Those eviction courts don't have any jurisdiction. They never have administrative tribunals, and they'll learn that the court's striking those laws down left and right. And it's going to apply in quote unquote state courts too, and for the same reasons. So it's really an exciting time, to be around and doing what I'm doing. Hopefully I have a good 8 or 10 years left here with family history being what it is. And I'm thankful for my great health every day. It allows me to do this at this age. So that said, remember to subscribe, like the videos, tell your friends. The sooner we get going up here to the U.S. Supreme Court and invoking other remedies that you'll learn about, the quicker we get the treasonous actors off our backs. Thank you.